Good evening, good evening, good evening. How is everyone doing this fabulous Thursday evening? Tonight is going to be an awesome night. Well, why is tonight going to be an awesome night? Tonight is going to be an awesome night because I have a special guest and we are going to learn some different. So, when we talk about asset protection, on the business side, things are going to happen in business. You will get sued, you may get sued. If you were to get sued, you want to make sure that everything is protected, right? On the personal side, we may be concerned with, protecting our assets while we're alive. We may be concerned with how we pass these assets on to our loved ones, those, adorable kids we have who are always great. Do we want the asset just to go down to one generation? Do we need it to go down multiple generations? I get so many questions about what is a trust? Do I need a trust? How do I set up a trust? So tonight, I have a very special guest, attorney Charlie Hands of the Hands Law Firm. So, Charlie, how are you doing this evening?
I'm all good. Happy holidays to you, Joy.
Happy holidays to you. I haven't seen you all year.
I know it's been a while.
That's my thing with you. I haven't seen you all year. Okay, Charlie, so before we get into the nitty gritty, why don't you tell everyone who you are and what you do?
Hey everybody. So my name is Charlie. I'm born and raised in North Carolina, still live in North Carolina, in Charlotte, North Carolina, and I am a trust estates attorney in Charlotte, North Carolina.
Awesome. Now, Charlie, what made you want to get into estate planning and dealing with trust and all that
I
good stuff?
I wasn't interested at all. It was my least favorite subject in law school,
Mm-hmm.
and then I was a real estate attorney, and then I kept having so many families and people having issues with estates and not having a trust and estates things in place. And so I looked at why is it such a big issue?
Mm-hmm.
And then as I started diving into it and seeing what the issue was and seeing it's like a legacy generational displacement type situation where it just needed some more knowledge given to people. That's when I became passionate about it, as opposed to just the law part of it.
Would you mind giving us maybe a scenario or two of what you saw when someone dies, if they didn't have a will or they didn't have things set up? How are the people knucking and bucking, cussing and fussing, arguing over the pots and pans? Tell us what you kind of experienced on the as being an attorney.
Yeah, I seen like usually it's dealing with a house or a business.
Okay.
So someone either like granddad had a family business for 40 years in the family, or there was a house like a family house,
Mm-hmm.
and then when he passed away in this example, um, now there's children or grandchildren who are supposed to inherit this, but there's no Willy Wonka magical thing that happens where the keys are handed over. On paper, it'll still show granddad's name, for example, as the owner. So if the children or the grandchildren are trying to do anything with that property or that business, their hands are tied because they don't have any legal authority to do anything. Just being a family member doesn't give you that legal authority.
Gotcha. Okay. Before we get to the business trust side, I wanted to first kind of dive into the family or the personal trust side. So I know a lot of people have wills and people think that I have my will, so I'm good to go. Would you mind telling the people on this live what are the issues with having a will and why you should look into having a living trust instead of a will?
So the good thing about a will is it gives you the power to choose who do you want to get what of things that you own, as opposed to when you do not have a will, the state that you live in will decide who gets what. So that's the good thing about a will. But what many people do not know about a will is that you still, as the beneficiary to it, have to go through this long and costly court process to have it done. Whereas if you have a trust or you set other things up that we'll talk about later, but if you have a personal trust in place, For example, bank account, I want to give this to my son or to my wife when if something happens to me. If it's in a will, it could take months for that to happen.
Mm-hmm.
If it's in a trust, 1 to 2 days.
Mm. Um, on average, how much are probate fees or the cost of having to take the will to court to divvy up the assets?
So at on the good side, if you have an estate and let's say, oh, I don't have much, I have a car and a bank account and there's not much, a lawyer to help you is going to charge thousands of dollars, at least $2,500, $3,000 to get through it. If you have an estate that's worthy of a lawyer saying, I won't charge you up front, they're going to charge a percentage. In North Carolina, it's usually 3 to 5%.
Mm-hmm.
So it sounds low, like, oh, it's just 3 to 5%. But if you have 6 figures worth of a house, you have a business that's generating income, that could be 20, 30, $40,000 being taken away from your family and going into a law firm's pocket. So the fees can get up there depending on what type of estate you have.
Mm. Okay. So I'm gonna talk to you like I'm just a regular person. So I'm gonna use real layman terms so everyone can kind of grasp the idea of the more complex things we're going to talk about tonight. So let's just get into what is a trust?
So a trust, think of so in real life, what a trust is sheets of paper, usually 40, 50, 60 pages of paper. And it just on the front page will have trust on it. So it's paper
Okay.
with ink on it.
Okay.
But conceptually, what it is think of a toy box and think of everything that you own in your name, that you have in your name, like your bank account, your car, your house, anything you have your name on are your toys.
Okay.
So if you want to create a trust, it's like you now have a toy box. And then the next step is to take your toys, the things that are in your name, and you put your toys into the toy box. Once they're in the toy box has a list of instructions of what is to be done with these toys.
Okay.
So if something happens to me, someone then will go to that toy box. They'll look at the instructions on the toy box, and it'll say, "Oh, the car is to go here. The business is to be kept operating and then wind it down slowly. The house is to stay in the family for whoever needs to live in it, or if they want to sell it." It lists everything out, and it allows the family to be able to make it happen without having to go through the court process and having a judge clear and decide things and making things take longer and cost more money to do the same thing you want.
Okay. One thing I'll add to that is when we're talking about family, everyone's family dynamic is going to be different. Okay. So there may be some strife between siblings, right? There may be two sets of kids. So daddy was married to the first wife and then now he has another wife. There may be a family member who's just, everyone has that crazy member who's just out of control, who's, always stirring up stuff. So if your family dynamic, and every family has some kind of in it, you want to make sure that when someone has died and we're grieving, that when we're having to deal with divvying up the toys out the toy chest, as Attorney Charlie was saying, that we don't have to be grieving our loss and then over here arguing, cussing and fussing and making the family break even more. Okay. So even let me ask you this question. If you don't have any assets, so maybe I just got married, I'm pregnant, and I'm like, I want to make sure my kid is okay, but right now I don't have anything. Can I still form a trust?
Absolutely. You can create the trust anytime in your life once you're 18 years old or older. And it's just like, hey, once you have your toy box, you have it. Even if you don't have any toys yet, you can have a toy box ahead of time in anticipation for when you do get some toys. So it's already set up for you. So you don't have to wait to get it.
Okay. Besides assets, what else, as far as like a medical power of attorney, a financial power of attorney, is that in a trust or no?
A trust have things such as not a medical power of attorney, but more like potentially guardianship
Okay.
language for like children, or if I have my toy box, I made my trust. If something happens to me, I can kind of double down on. I would want this person to be my guardian over me if something happened to
Okay.
me and I'm still alive. Um, but yeah, mainly it's concerned with the toys that you have and more the more personal things to that person.
On average, how much does it cost to set up a trust?
So this varies, right, across the board, depending on what are you trying to get and what works for you. So you could potentially get a trust off, and I don't want to quote them the wrong numbers, but LegalZoom for maybe a few $100s or $1,000. I don't know what their price is, but the disadvantage to that is you're not having a trusted advisor. You're not having a personal family lawyer guide you through the process and make sure you know someone that's an expert in that field help you with it. Then if you get a trusted advisor or an attorney, it depends on that attorney, right? But what I've seen across the board, across every state, minimum is usually about $1,500 to get like a bare bones standard trust working with a lawyer. And then it could go up from there depending on what you're adding to it, or which attorney you're working with in which market.
Okay. I am a firm believer that there are certain things that we don't need to always get the cheapest. So, as an attorney and, experiencing, family fallout or disputes, can you maybe share why we would need to go through an attorney for a trust versus a document preparation company like LegalZoom?
Yeah, if you so a trust is really very, very complicated, right? It's actually real complicated law, and it's made like that for a reason. But it's like that. And so if you're gonna get something as important as this is the thing that I'm relying on to make things easier for my family, that when I'm gone, my entire family or my beneficiaries are gonna rely on this, that's serious. Like that's not just oh, I just want something for tomorrow. You want to make sure it's airtight and it does the job. Two, when you're gone, you don't want your family to have to turn to a stack of papers or some papers you got off the internet that they don't understand or know what to do with. So with the clients at Hands Law Firm in Charlotte, they have their trust, they have their paperwork. It was explained to them thoroughly. But what most people are doing, they're gonna call Charlie. Hey, um, my dad just passed. Hey, my grandmother, you did her trust in 2019. Now she's not here. We have all the paperwork, we have all the summaries and everything you did, but they're picking up the phone and they're calling their personal family lawyer who's gonna just make it easy for them.
Okay. Um, any kind of legal documentation, it needs to be done by an attorney and then explained to you. I see a lot of people want to get a contract off of Google. Okay, so you have a contract and it has a title, but is the language of the contract, is it protecting you? Do you understand what the contract is saying, or do you think because I have a contract that I'm good? If I wear a size 10 shoe and I go pick up a size 5, because I maybe the box said a size 10, but inside was a size 5, I can't do anything with the size 5 shoe because I'm a size 10. So it's kind of like I have the shoe, but I can't do anything with it. So I see a lot of companies online that do trust and $100. Like when it comes to passing things on generation to generation, you want to make sure that your loved ones are not having to argue, fight, scram, look. Forget fighting. Let's say everyone is copacetic. A lot of times, if your family can't get to the money that you have, they may not have enough money to bury you. I had a situation where I knew someone that died and they had a life insurance policy, right? And they put the life insurance policy in their granddaughter's name, and their son, the grandchild's father, was the person who could dictate what went on. I forgot what it's called. But in life insurance, since the granddaughter who was 6 was a beneficiary, they didn't find out until the person was dead. The money's going to go into a trust, but she can't touch the funds until she's 18. So the dad thought the granddad thought he was giving enough money to his family to bury him and have enough money for the grandchild, but didn't understand that if I make this grandchild the beneficiary, the money won't be touched until 14 years later. So now the family is scrounging around trying to come up with burial costs, coffin, the morgue, all this kind of stuff, adding more pressure as everyone's already grieving. Okay, so saying all that to say, you don't just want to trust. You want a trust, and then you want to be able to talk to someone who went to law school, who understands what the language is, and can explain to you everything in that trust. So you understand, I'm protected. The grandkids getting this, my mama's getting this, my kids is getting this. If I acquire, well, let me not go ahead of you, Charlie. But you want to make sure that whatever you have, it works for you. Okay. There's a whole bunch of different types of trusts, just like there's a whole bunch of different types of cars, right? If I'm single, do I really need a Suburban? Well, the Suburban seats 7 people. It has a really big trunk. You can kind of get all these people in here and all this luggage. But if it's just me, do I need a Suburban, right? So you want to make sure that you have what you need. So, Charlie, I've heard a lot of things about trust, like a revocable trust, an irrevocable trust, a family trust, a business trust. Do you mind explaining what the different types of trusts are?
Yeah, so as far as names, there's probably 300 different names people have come up with for whatever their toy is, right? Land trust, house trust, business trust. But legally there's really 2 different types of trust. And I saw this in the chat: revocable and irrevocable. So what most families and most individuals and business owners are using is revocable trust. That means they have control over it while they're alive. So what it does is, right now, everything that you all own in your name, you have full control over it. Your bank account, if you want to go and close that bank account, put money in, take money out, you have control over it. With a revocable trust, it's the exact same thing. Is revocable. It's called that because you can revoke. That's just a fancy way to say you can put toys in and you can take toys out. Taking a toy out is revoking what you put in.
Okay.
But you have control. Irrevocable means you have the toy box, but the toy box is put in someone else's hands or in somebody else's house. So, and the toys could have your name on it. So it's your toys and they're for you, but you don't have control over them anymore, but you can benefit from them. So we can talk about that later. But most people they keep the toy box in their house, in their hands, with their name on it, and it's just an extension of them.
Okay. So why do I need a trust? Why do I even need this?
It makes things easier for your family and for yourself, because it's a toy box. You have all your toys, all your items, all your assets that you own. You put it all in one place. So it's all in one place. But again, it just makes things easier. So just to give an example, I use the bank account example. I'll use the house, for example. If a house is being left to children and then you don't have it in a trust, a lot of times what happens is the house has to go through probate, and that's court. And to go through that, things have to be filed in the newspaper. Potential creditors are alerted that this house is going through this process, being handed down to these children. So if a creditor is owed money, they could try to come in and put a lien on the house, take the house. That's what Medicaid is known for by a lot of people. Whereas if you have it in a trust, you can have the same words where, hey, I want this house to go to my children, but it stays out of the courts. So the courts isn't going to put it on the public record, and the children within the privacy of their family can make the transfers happen. And usually at this time, people are getting their personal family lawyer to make sure the transfer happens. All right, let's update the deed to the house into the children's name or into the child's name, whatever the trust says. But it's a seamless, hey, we can act on this now, and we don't have to wait months, and we don't have to pay a whole bunch of money to the court or to another law firm just for the same exact thing to happen.
Now, what if I put assets in my trust and I get sued? So maybe I was in a car accident and I killed someone and I got sued, but my car and my home were in my trust, not in my personal name. Will that help me at all or no?
It helps you if you have an irrevocable trust. So that's the other one that we said is less common than having the revocable. So again, the revocable means you have full control and ownership over it. So if you get sued, there's no separation really between you and those toys. So they can, if you're holding the toy box with the toys in it and someone sues you, they can get those toys.
Okay.
But if the toy box with your toys in it is in somebody else's house, and someone comes in your house and sues you, your toys are nowhere inside, nowhere in the house. Or if it's you can call it a burglary. Your toys are nowhere to be found. So what that means legally is, oh, I don't own these things. I'm the beneficiary of them, but the box is over there. So if someone sues me, that's when you have that protection, when you don't have control and ownership over the things anymore.
Okay. How long does it take to set up a trust?
My process at Hans Law Firm, we're a part of the Personal Family Lawyer Network, and we use pretty much a 30-day window. Once you make payment, about 30 days from payment is when our clients come in and we have our signing ceremony or our signing day. And that's when they come in and they sign all of the paperwork. And for our people, we're not just doing a trust, we're also doing the power of attorneys you mentioned earlier, Joy, the medical directives. We're doing everything. So it feels like a real estate closing on that day, but it's about a 30-day window as far as that timeline.
Now, you mentioned a medical, what'd you say?
Power of attorney or directive.
Can you tell the people what a medical power of attorney or a medical directive is?
Absolutely. So anyone, if you are 18 years old or older, everyone 18 years old or older should have power of attorneys. Case in point, there was a college student that was 19 years old in Charlotte, was in a car accident and was temporarily paralyzed. She was 19 years old. Her grandmother and mother came to the scene and was trying to withdraw her from school. She was in college and was trying to talk to the medical doctors about her treatment in the hospital. So this is their baby, right? Hey, that she's 19, but it's like, oh, she just left the house. But once you're 18 years old, hey, you're considered a full legal adult, and you have to give someone the authority to be able to come in if you're not able to make decisions for yourself. The reason for that is because you could be estranged from that mother or grandmother. You could not agree with their decision making. And so if you come back and say, I wouldn't have wanted them to have that authority over me, you could then sue the company or the institution that gave them that authority. So with a power of attorney, if you ever become incapacitated and can't make decisions for yourself, but you are still alive, it gives you the ability to name who can come in and make those decisions. If you do not have a power of attorney, the family or your spouse or whoever it is, best friend, they can come in and still make that happen, but they have to go through court to do it, filing a guardianship over you. So again, just like with the trust situation, if you don't have a power of attorney, court costs a lot more money. It takes a lot more time to go through that guardianship process as opposed to having your power of attorney already in place.
Can you maybe go over what is a financial power of attorney?
Yeah, so there's two power of attorneys. One is financial. Some people call it a durable power of attorney or general. That covers any decision making you will want someone to be able to make when it comes to anything except healthcare. So for healthcare, that's considered a personal, intimate subject. So there's a separate and second power of attorney solely for healthcare decisions. And you can name the same person to be your power of attorney in both of them, but sometimes you might change who that is based off people's strengths and weaknesses. Where you could say this person is good in finances and business and they have good business acumen, that's going to be my financial power of attorney. But this person, he or she was a nurse, or they're more compassionate, they're the type that would stay overnight in the hospital next to me in the bed and talk to the doctors, I want this person to be my healthcare power of attorney.
So to kind of give an example, let's just say you were in a car accident and maybe you were just under for like 2 weeks, right? You were, tubed up, but the first rolled around. You have the money for your rent, but you aren't able to pay the rent, so now your rent is 2 weeks late. Or let's just say you're in the hospital and you can't move for 2 months. Well, now you're about to get evicted and the money is sitting in the bank, but no one has the authority to walk into Bank of America. I don't care how much your mama go in there and cuss. This my baby. Once you become 19, you don't have a mama no more, right? The bank ain't about to listen to no one up there cussing and fussing. And now you about to have all your stuff on the front yard. On your front lawn, you're about to be evicted, and you're about to lose everything you had simply because someone couldn't just touch the money you already have to go pay it. Okay, so everyone on this live, I'm sure you're 18 or over, you need to make sure that you have a medical power of attorney, a financial power of attorney, and either a will and a trust. Now, a trust doesn't come with those documents, meaning they're not in the toy chest, but when you get your trust done with an attorney like the Hands Law Firm, you'll give them the trust and these additional documents, correct?
Exactly. So they're separate documents. Trust, you got your 2 power of attorneys, and then there's others, but they're separate documents that create the whole package for you.
Okay. Now, if someone wanted to talk to you, Charlie, they want your opinion as to what they should get done, how do the people on this live be able to contact you?
So if you are if you live in North Carolina, or if you're able to travel to North Carolina, then I can be your personal family lawyer and complete your trust plan, the state package plan there. Let's say if you're in another state and you have no touchings with North Carolina and do not plan to come to North Carolina, then I'm not the person that you can work with. But if you call us, I can direct you to someone that can work with you in the state that you're in. I mentioned earlier, I'm a part of the Personal Family Lawyer Network. And so what that means is everyone in that network, we all use the same system. And our system is to put people first and have a relational relationship with our family, with our clients when dealing with trust planning and things of that nature. So if you're connected with a personal family lawyer in the state where you're in, you're going to get the same type of treatment as opposed to a cookie cutter, LegalZoom template approach that many others might give you. For me specifically, at Hands Law Firm is our IG. All of our information is at handslawonline.com. Phone numbers, and again, we're in Charlotte, North Carolina, 704-248-7976.
I will, when I post this live, I will post his the law firm's Instagram handle and phone number. But I want to just stress the importance of having an attorney for legal documents. Okay, I know a lot of business owners are on here and we like to do it ourselves, but there are some things that we do not need to do ourselves, and this is one of them. Okay. I saw in the comments someone wanted to know, can you get a power of attorney for someone who's under 18? And you cannot, because if you're under 18, you're a minor, and so your parents will be able to cuss and fuss and be able to regulate on your behalf. Okay, but once you become an adult even if, you know, your parents are still taking care of you, the law says you're an adult, so no one can speak on your behalf. What are some things that you want the audience to know about trust, your services, anything like that?
Well, Joy, I saw a very good question earlier when I was first talking about toys and the toy box with the trust. Someone asked, "What if the toy is not paid off?" And I highlighted that question because when I was creating the trust for a lot of people in my family, that's what a lot of people in my family were saying. Charlie, I can't. Well, I can't do that. I still got a mortgage on the house, or I still got money owed on the car. Just because you have money owed on the toy does not mean that you cannot set it up to make things easier for your family. So all it is, that's two separate things. So if you have your house, you have the title to the house as far as who owns it, and then you have a mortgage on it, for example. We're not changing the mortgage, we're just changing who owns it. So if it's my trust, for example, instead of Charlie being the owner of this house with a mortgage on it, Charlie will own this house as trustee of the Charlie Trust. It just changes the title wording. That's how you put the toy in the toy box. And you can have your toy in the toy box with money still owed on it if it's not paid off.
Okay. I haven't had an estate planning class in 20 something years. So what is the clause where you can form a trust and you can have a clause where even if you don't name an asset in and put, and maybe if you don't name a toy in the toy box, upon your death, if they found a toy in your room, if they found other assets, it would then still go into the trust.
You said there's a toy that it's not in the toy box.
Correct. Like you didn't list it in the trust. Assets that you don't list in your trust, but upon your death, all your assets will still go into the trust if you forgot to add an asset.
Oh, you're talking about like pour over.
Yes.
Yeah, that's the term you're looking for. But no, very important point. So again, I mentioned the Personal Family Lawyer Network. And I believe I'm gonna check, but it should be the personalfamilylawyer.com. What we do is we set up backups in case that happens.
Okay.
So usually what happens with people, and I saw this in the real estate world, they'll have a trust and they don't have all the toys in the trust. So what that means is the default is, oh, the family has to go through court to pour that back into the trust.
Okay.
But again, the goal is to avoid having the family go through months of court and paying all that extra court fees and attorney's fees. So there's legal backups you can put behind the trust that I do with my clients and personal family lawyers do, where, okay, you forgot to put this toy in the toy box, but we'll have a legal document behind, two of them, behind it that says, even though I forgot to put my toy in the toy box, I made this trust for a reason, and I declare that I want my toys that I own when I pass away to pass through this trust, through this toy box. A lot of times it works. One of my clients, it happened with a bank account, a Wells Fargo bank account. It was one bank account they forgot to put in. The initial person on the phone said, oh, it has to go through court and you got to months before we can transfer it over.
Mm-hmm.
But I was able to talk to a manager and show those legal backups. And then they just typed on the computer and boom, it was as if it was in the trust. And they was able to get that account in 2 days.
Okay. So situations what happen like that also, like, let's just say you bought a car outright on Friday and you didn't get a chance to go see your attorney on Monday and you die on Sunday, right? So there are ways, and this is why you need to have all legal documents, drafted by an attorney, because we have gone to law school, to understand all the exceptions, right? You can Google all the rules, but the experience and the knowledge is in the exceptions, okay? So if this were to happen, then what? If this happened, then what? So we don't need the prepaid legal Zoom, legal shield, all that stuff. Those are document preparers. And they're, if you look on the bottom of their website, they're going to say, we are not a law firm. Okay. So when it comes to your assets, and when it comes to making sure that your loved ones are taken care of, you don't want to have paid money and think everything is set up and you're gone, and your loved one, your family, we are now losing the house because something wasn't done correctly. You thought it was, and no one had the money to fix it. Like, a lot of things happen. Okay, so you want to make sure it's done correctly. Okay, it's not 3 powers of attorneys. It's going to be 2 powers of attorney. It's going to be financial and medical. So the 3 documents he was saying is, he'll form your trust, which is just a whole bunch of paper that explains where do you want your assets to go. And you're going to get 2 powers of attorneys, a financial power of attorney or a durable power of attorney, and then a medical. So someone's going to decide what happens to you. Do you pull the plug? Do you stay on life support? Would you want surgery? Would you want a blood transfusion? And then someone's going to dictate what goes on with your money. Okay. Anything dealing with kids would be a guardianship. So if husband and wife, if husband is like, if one of the spouses, if one of the parents is dead and it's just one living parent, and then that living parent is sick or is in the hospital, that parent can dictate, where do the kids go? Are the kids going to grandma? Are the kids going to my sister? Are the kids going to the in-laws? Like, if I'm on life support for 2 months, who's at home with the kids? Who is taking them to school? We don't need mama and mom-in-law, knucking and bucking. You don't want to see all these things bring in strife, right? We're already stressed because my daughter's on life support. Depending how things ended between husband and wife, mom maybe still be mad at dad's parents, right? So she already got a chip on her shoulder. Now we're not letting the grandma see this. It's just like a domino effect. And I've seen it over and over again, right? As to when things are not lined up, when you don't say out of your mouth on this paper, the kids is going to my mama. So mama-in-law have a seat, sit down, they ain't going over there. Or the kids is going to my sister. You want to make sure that everyone knows what's going on and that it's your will. Same with medical things. She told me to keep her on life support. She told me she don't want to be no vegetable. So now they're in the hospital going back and forth. All that is extra strife, and they're already grieving what's going on with you, or they're embarrassing you at the hospital, either or, right? So you want to make sure that all of these things are handled, okay? Can you do someone's power of attorney and financial power of attorney if they're not in North Carolina, or you only do things for people in North Carolina?
Yeah, it has to be North Carolina for me. Either they already live in North Carolina or they travel to and they're currently in North Carolina when I work with them.
Okay, so I can travel to North Carolina because I like you. Have you set everything up? I sign on the dotted line, and then I'm good.
Exactly.
Okay.
And the reason why is because then once you go back to your home state, the states all talk to each other as far as respecting things done in other states. So if you had something done legally and by the book in another state you were in, when you're in the state that you're back to, then they're going to honor it at that point.
Okay. So if someone has a living trust or a trust, do they need a will and a trust, or they just need a trust?
So I kind of was getting to it when we were talking about the pour over and the backups. So with my system, what we do with the personal family lawyers is we have your trust. We have 2 legal backups behind the trust where if you forget to put a toy in the toy box, those 2 legal backups are going to just presenting them will catch it and we don't have to go through court. But the worst case scenario is if you do have to go through court after going through all 3 of those barriers, then what the court system looks at, they don't ask if you have a trust or not. They ask, do you have a will or not? So we'll have a will as a final safety net, worst case scenario where, okay, judge, we have a will here. And the will just simply say, Charlie made a trust, and it references when it was made. put this toy in the toy box. And it makes it real clean and simple as possible if that did happen. But the goal is that never happens, and we have everything up front in the trust, in the toy box, ready to go, airtight.
Okay. Okay, so someone asked a question about everything being state specific. Things are state specific, but like he said, if you go to a certain state and you get something done, then is it reciprocity? Your home state will honor the rules of the state that you got in. So let's just say I'm in North Carolina, I get my will, I get everything done, and then my husband's job transfers us to California, right? Well, we don't have to redo all that stuff because we already had it formed in North Carolina. Upon our death, California would say, well, you had this, trust formed in North Carolina 5 years ago. It was done correctly under North Carolina laws. So we're going to follow North Carolina laws, although you are in California. Okay. So that is how that works. Are trusts taxed at all? If I have a trust, do I pay taxes on that?
Yeah, I had that noted, Joy, to talk about taxes and trust. And just so y'all know what that state to state communication thing is, it's like a constitutional thing called the full faith and credit. That's like the term for it, full faith and credit. We're gonna give faith and credit to North Carolina's laws for this person that's in Texas, for example. But with taxes in a trust, when you have that most common trust where you maintain and own it, that's the revocable trust. You control it. Nothing changes for you while you're living for taxes because it's just an extension of you. It's not another entity separate from you. So that trust, you don't have to have a new tax ID number made, and nothing for you changes with the trust. So that's why when we talk about trust planning, it's recommended to do because nothing for you really changes once you. It's not a hassle. Only thing that changes is on paper. Charlie owns this as a trustee now of the Charlie Trust. But as far as in real life, I still have access to my bank account the same. My taxes are the same. Nothing changes to make things harder for me at all in real life. If you have the irrevocable trust, or if you pass away and you left a trust for your children, and it's an irrevocable trust at that point because it's you made it and it's for them, at that point, that's when the trust is a separate thing. And that's when a tax ID will be created for it to have its own tax situation and tax returns filed for it.
Okay. So, if you don't, if you're not able to control the assets in an irrevocable trust and you have a trustee, who pays the trustee?
The trustee can either work without compensation, very common, especially if it's someone that's your, like, let's say, oh, that's my best friend,
Mm-hmm.
and and we're each other's trustees, and we just
Mm-hmm.
do this to win in the game, the trust game.
Mm-hmm.
Or the trustee can be paid out of the trust. So if the trust, let's say, has income, if it has just liquid money assets, the payment is usually it's called a reasonable fee,
Mm-hmm.
and it's just based off of the time and effort that the trustee puts into managing the trust. So if it's like a trust estate picture where, oh, the trustee really doesn't have to do anything, then there's not really no compensation to be paid. But if it's a situation where, man, this trustee is really, it's like a job, a full-time job,
Mm-hmm.
the trustee can get reasonable compensation based on the time and effort put into that.
Okay. For those who are just logging on, maybe a little late, do you mind saying again, how do you actually form a trust and what is a trust?
Yeah, trust is sheets of paper with ink on it in real life, but conceptually what it is a think of a toy box, and you have your toys, and your toys are the things in life that you own, that you have your name on. Bank account, I got my name on this car title. I own a house, so I got my name on the deed or the title to the house. Those are your toys. And once you create your trust, which is signing the paperwork that creates it, then you have your toy box, and then from there you put your toys in the toy box. What that looks like is changing the title to the toys. So if you have a car title that says, oh, this Toyota is owned by Charlie, then I would then change the car title at the DMV to give it from Charlie to myself as trustee of the Charlie Trust. So then the car title would just say the owner is the Charlie Trust. And then I'm the trustee of it while I'm alive. And then you do that for all of your toys. And then that's how you have all of your assets in the trust.
Okay. And once again, as long as you have control of the assets, so you form a revocable trust, there are no tax implications. But as soon as I make it an irrevocable trust, meaning I don't have control over the assets, if the assets are producing income, so if I put a business in the trust and the business produces income, then the trust now has to pay taxes?
Yeah, if you make it an irrevocable trust, that means it's like you gave it its own life. It has its own legs, arms and legs. It's its own thing now. So once that's done, it has to have its own tax picture. Just like when you create a business, it has its own situation now, separate from you. So, oh, I own this business, but it has to have its own taxes done. It'll have its own bank account. It has its own life. The irrevocable trust, same thing. It has its own life, and but you don't control it like a business. The trustee that you name will be the person that controls it, or the company that controls it, and then you could be the beneficiary to it. Just to give some common examples of the most common reasons why people make the irrevocable trust. Let's say I'm older in age, and I think I may have to get long-term care. And long-term care or nursing home care is very expensive.
Mm-hmm.
And let's say I'm middle class and I have some money, but I'm not super rich to be able to pay $30,000 a month continuously nonstop. So if you don't do anything, what happens is, if that situation comes to be, you have to drain all your money down to either $2,000 or $0, depending on the state you live. And then that's when the government and Medicaid will come in and cover the expenses of the long-term care after you're about down to $0. Or what you could do, you make an irrevocable trust, you put all of your money and your assets into that. So now you then can go to apply the Medicaid or Medicare at that time. And on paper, I don't have anything. So now I can get all of my medical expenses paid for, and I can still maintain the legacy that I built in my lifetime to leave to my children or to my whoever it is, my spouse. That's one common example. Another second common example I see is if you have a special needs, if you're special needs or you have a special needs child, where again you're getting governmental benefits because you have that condition, but you want to make sure that they're not going to try to put a lien on your house and take
Mm-hmm.
it later for giving you those benefits. You have it separate from you, you get those benefits, and you can still preserve what you've built in your lifetime.
I'll add a third reason why you may want to get a revocable trust. If you have property that you want to be passed down, right? So we have a family home. Maybe grandma had the home and then we had the home, and we just want this home to stay in the family, right? Or maybe you have a younger child, or a younger meaning not mature child. I don't want to die and give my home to my 19-year-old son, and then he sells the home and takes the money and buys a sports car. So I will put my home in a revocable trust, so he can't. Hold on, can he sell the home, Charlie, if I put it in a irrevocable trust? Before I just speak out of
So
turn.
let's say the son is beneficiary, irrevocable trust. Whoever the trustee is the person that will sell it, but
okay, not the son.
not the
Let
son.
me
Right.
change my example. This is a common one. Your kids get married and you may not like you don't know who your son gonna marry, right? He may stumble upon a little hot mama who you know is only after him and don't really love him, right? If you put your asset in an irrevocable trust, when your child marries, so maybe your son may marry someone he shouldn't, and your daughter may get caught up, whatever the case may be, that upon marriage, everything becomes community property, right? But if you put your assets, you put the home, the bank accounts, whatever, in an irrevocable trust upon your death, that property remains separate. Meaning, although your son, the only son, or your only child, marries someone and they get divorced, they won't lose the family home upon divorce. So it's a way to preserve assets, going generation down to generation. And when you're dealing with, divorce and those kind of things, a lot of times those assets can get lost upon dividing of the community estate. So it makes sure that this property remains separate property, meaning upon divorce, you won't lose it. So there's different reasons as to why you would want a revocable trust or an irrevocable trust, what you want to put in the trust. But if you have a revocable trust, that means that you have control over it, right? So nothing changes tax wise. Nothing is really going to change as far as the day-to-day operations. You have control over. Upon your death, the asset will then be, distributed based on what you have or what you want in the trust. If you put it in an irrevocable trust, our hands are not on it. So it will have its own EIN number. If it's producing income, maybe you have rental property in there that's producing income, you may have a business in there, then it will file a tax return. So you want to always make sure that you have a consultation with an estate planning attorney in your state so that you understand what is best for your scenario, what are your options. And it's not like a one size fits all, but everyone needs to have a living trust, a medical power of attorney, and a financial power of attorney, just to kind of cover you for the basic things.
Absolutely. And it's what people, the most common combo that I see people do is they make a revocable trust that they own and control during their lifetime. And then let's say the classic, I'm leaving things to my children or to my spouse and children. When the person passes away, their trust transforms and morphs into an irrevocable trust upon them passing away for their children. And so then it doesn't matter, like you were saying, Joy, dealing with spouses or if one of those children gets sued, everything that you left for your children as a legacy to them is preserved and protected. And I call that a lifetime asset protection trust where, hey, I know that what I'm leaving for them will stay for them and it will be shielded from whatever financially negative could happen in their life. Divorce, lawsuit, medical lien, medical bills, anything like that, it's protected from it.
Charlie, speak a little bit upon the importance of dictating where you want things to go, because you may not want your assets to be distributed based on state law. So maybe we're in a second or a third marriage, right? Yeah. By law, the spouse gets whatever you have, but you may not want, your new wife of 2 years to have everything. You may want it to go to your kids. So can you kind of speak about when we have a blended family or multiple marriages and, multiple sets of kids, and, why it's important that you really want to pinpoint where things are going, because what you want may not be how the state heirship rules are going to say things should go.
Yeah, I'm glad you asked that, Joy. So let's do the blended family example. So let's say I'm gonna create a hypo. We have a husband, man who has 2 children before he met new spouse, and then there's one child that wife had before her husband, and then they might have children in their marriage or not. So let's say what the states normally say is the first spouse that goes. So let's say usually the men pass away first. The man passes away first, and the state will then say the lion's share of everything is going to go to that spouse, to that wife. Then she passes away. The state will then say, everything she now has goes to her biological children. So the biological children of the husband is completely not even considered. Correct. They have no standing or claim at all to anything that was left to the spouse. And it usually doesn't come up until that both spouses are gone, because it makes sense for most children. Oh, okay, dad, everything went to stepmom. We get it. She's still alive. They were together and married. But then they expect, all right, wait a minute. My dad had some stuff, and you mean to tell me everything is going to my stepbrother, or stepsister? So if you just leave it to what the law says in the state that you're in, it's just that brutal as far as, all right, biological children, they're not looking at your situation and tailoring it to you.
Correct. And you don't know, like, let's just say we have a big family home. Well, if my kids may not have an issue with stepmom living in the home, but they're thinking upon her death, I'll be able to sell the home and get what I got to get. But upon her death, it's going to her kids. It's skipping like a whole line of heirs. So understanding heirship laws, what is it called in common law? I went to Louisiana for law school. It's not heirship.
Intestate succession.
Thank you. Intestate succession. In civil law, it's called heirship. So intestate succession, understanding who gets what upon your death is very important. That's why we don't want to rely on the state law, because your state laws may not benefit you, especially if we have blended families, more than one marriage, or you may want to skip. Like you have the right to skip. Like I may not want my kids to get nothing, right? I may want to give it to a charity. I may want to skip them and give a right to the grandkids because I feel like they aren't going to do right with the asset. You can do all of these things if it's written down in paper in a will, preferably a trust. Okay. Anything else you want to add, Charlie, that we should know?
I saw a good question earlier. How hard is it to make life insurance make the beneficiary of life insurance a trust? So depending on the life insurance that you have, again, life insurance is a toy. I own this policy of life insurance. It depends on the company you have. Some allow you to go online nowadays and just type and upload your trust document and change the beneficiary on the computer. Or you might need to call your life insurance agent. But all you're gonna do, and like with my clients, we create a 4-page document. So the trust could be 50, 60, 80 pages itself, but you have this 4-page document called a certification of my trust, proving that it exists. That's what you give to a life insurance agent or a banker, and you just give it to them and say, hey, I got this trust, all the details are right there, and I want to put my life insurance in the trust. I want to put my bank account in the trust. Everything that they'll need on their end is on those 4 pages of paper, and it's very, very easy to do. So none of my clients have had any issues with any difficulty putting their toys into their toy box.
Okay. Let me see if we have any questions we missed.
We had some LLC business questions where I saw, if you have a business, should the business own the trust, or should the trust own the business? Again, and I think I kind of mentioned it earlier, everything that you own is a toy that you put in the toy box. So a business, if you are the owner of a cleaning service, or you're the owner of this whatever business, that's a toy, because it's something that in your personal name you own. You would just change the owner of it from yourself to the trust. So in a way, if you look at, I know a lot of you all might do like flow charts, or like I forgot what you call it, like the parent company, or the things like that. The trust is usually at the top, owning the business, and then the business maintains ownership of, it can have its own business bank account in the business name. If I saw someone ask about business equipment, that business still owns its equipment. So nothing for the business, again, changes. It's just at the top of the chart, the business is owned by the trust, and then you own and control the trust.
Okay, I saw a question about inheritance tax. Nothing gets out of taxes. So Trump change the estate law. I think, what is the cap? Is it $1 million?
Yeah,
What's the amount for estate planning tax?
when I last
I
looked,
mean,
it was
estate
like
tax.
11.5 million.
11.5 million?
Yeah, exemption. So let me talk about the estate tax. So in the early 2000s and stuff, it was a lower number. When Trump came in, the number is very high. Where if your estate isn't over $11.5 million, then your family and your estate will not have to pay any taxes for your estate when if you pass away or anyone in their estate passes away. Once you get over that number, that's when you have to start looking at estate taxes. For the most majority of people, estate taxes is not anything to worry about. Inheritance tax is something that's usually state specific. In North Carolina, we have zero inheritance tax. What that means is if my dad or mom pass away and leave me money in a bank account, I don't have to pay any taxes for receiving that as an inheritance in North Carolina. Now you have to check your state because different states could have different rules. And the only other tax that could exist, Joy, inheritance tax, estate tax. Oh, state. So state level estate tax. So the exemption amount that we mentioned earlier is federal estate tax. Your state can have an estate tax as well. Again, North Carolina has zero estate tax. I think most states they're not big on. They kind of follow the agenda of the federal. So it's not usually an issue with most people with estate taxes.
Is the estate tax still 40%, or did it go up or did it go down?
40% when I last looked. If you get,
Okay.
and again, that's if you go past that number. Um, another another just important thing for people to know. So a lot of people are starting to find out about gift tax. Like, oh, you get $15,000 a year or whatever the number is. And disclaimer, I'm not a tax person. I'm not a CPA or a tax attorney. So that's why I'm not giving precise numbers. But again, when I last looked, oh, every year you can give $15,000 worth per person to someone without paying any taxes. The rule with that is if you go over that number, then they're gonna count it against your $11.5 million federal exemption that we talked about earlier. So even then, for most people, gift tax isn't an issue because you have that $11.5 million coupon now
Mm-hmm.
to charge against.
Okay, so I am going to once again put Charlie's law firm information in the caption in the caption when I post this live. I'm saving this live. I'm going to post it on my page, and so you can contact him. His law firm is called the Hands Law Firm, and you can set up a consultation with him. He can do your trust, your power of attorneys. If you're in North Carolina, if you go to North Carolina. If you're not in if you're not in his state, he can refer you to an attorney in your state that does the same thing that Charlie does. But I wanted to kind of get this information out so we at least know what it is we need. So once you know what it is you need, the next thing to do is getting a game plan as to how we're going to get this done. He mentioned that, a baby trust is starting out at about $1,500. Depending on how complex the trust is, how much you're putting in it, the fee can go up. I always recommend going through an attorney to get, any kind of legal documents drafted. We don't need to be going to LegalZoom or any kind of document preparation company, because when we're dealing with assets and heirship and descendants and who gets what and who's doing what, you want to make sure that one is done correctly, and then two, you want to have someone that's going to explain what all of this says so you really understand what you have. Do you need to have more than one trust, or or no?
Most people that have one trust for themselves, or if it's a married couple, what most married couple do is they have one joint marital trust. But married couples can also have separate trusts for each one of them, depending on their situation, blended family. But even with a blended family, you can have a joint marital trust. But usually we're having one trust in play, unless we're doing some advanced estate planning, trust planning. Usually you're over the $11.5 million mark, and you're trying to cut on taxes and things.
Is David on here? Is David going to pop up for a second and show his face and just say hi? I'm going to do another live on how bankruptcy can be used for asset protection. Okay, so I know a lot of times we hear bankruptcy and we think, oh my gosh, we're going to lose everything, you know, blah blah blah. But there are different types of bankruptcy. You know, I'm not a bankruptcy attorney, so I'm going to just stay in my lane. But for the general concept, there are different types of bankruptcies, right? And there is a type of bankruptcy where you can keep all of your assets. What they will do, they're going to put all your assets together, and they're going to actually reduce what you owe and what your payment is. And then you make payments to your trust and you're able to keep all of your assets. Okay. So you go out and you get a loan for your business, right? We have a tough year. David, you are here. Do you want to hit this little button and request to join? You don't have to talk, David. You can, I just want them to see your face and just say hi to get them ready for the next live. If you're not ready, I understand, David, but you can actually make payments and they're going to be lower payments. I know it's because I have a dealership, and we actually repossessed a car from a client and he went and filed bankruptcy. Okay. So if you file bankruptcy, I think you have 7 days to file. Don't quote. David, look on the bottom of your screen, you'll see like a camera and a plus sign. If you hit that, it's saying like request to join, and then I wonder if I can I ask David? Let me invite you, David. Oh my God, look at big David. Come on, David. Come on.
And you have to be on your phone, David, if you're on the computer. David. I don't think he'll show it for him.
What is David's Instagram? Is it
David _ hands, HANDS.
David _ hands. Bam. Okay, I invited you, David. Okay. So I forget what the time delay is. This is a way to keep an asset. Hey, David, how you doing?
Hey, what's up, Joy? Let me turn this.
I'm talking about bankruptcy.
I gotta work this Instagram thing.
See. I'm talking about bankruptcy, right? And I know this because I have a dealership. I repossessed the client's car, and this bankruptcy attorney called and said, "Well, we're going to file bankruptcy if you don't return the car." And I was like, "I don't care, filed," not knowing, oh my gosh, if you file bankruptcy, I got to give the car back. So after she was doing all of that, you know, I called a bankruptcy attorney. He's like, well, no, you have to return the car. So I, as a dealership, ended up having to hire a bankruptcy attorney, and I had to give the car back. They were able to reduce their car payment by like $200, and I had to let them keep the car, and I got less money every single month for the car payment. Okay. So
Absolutely.
I don't think our community understands the benefit of bankruptcy, because in business, you may have got a loan, you may have stretched yourself too thin, you may have had a rough year, a rough season, and you know, we are trying to hold everything together and we just can't. Sometimes filing a Chapter 11 bankruptcy, you can get rid of the debt, but still be able to keep the assets. So if you want to say any two things, David, you can. I'm not going to put you on the spot, but I want everyone to understand I'm going to do another bankruptcy live so that we understand how do we keep the asset after we get it when we do kind of get into a little trouble.
Absolutely. So most people, they believe that if you file bankruptcy, it's over. But what I try to educate, especially, you know, it seems like African-American community, the Hispanic community, we have no clue on the power you can wield with filing a bankruptcy. Bankruptcy's main goal is to help protect your assets. The rich know that. Look at our former President Trump. He has filed 4 bankruptcies. Now, he hasn't filed personal bankruptcies, but but he understands, and most people with money understand the way to use bankruptcy to work it as a tool to help protect your assets. And it's really important. I love what you guys are talking about now about building assets and protecting assets. But if everything goes haywire and you lose and creditors are coming after you because you had a bad business deal, you need to understand what bankruptcy is and what it can do for you. It's not necessarily something that's going to ruin you. It's designed to give you a fresh start, almost like your one do-over. So
exactly.
I can't wait to talk to you guys about bankruptcy. I think it's going to be very informative.
Okay, so this is David of the Hands Law Firm. So we have Charlie and David of the Hands Law Firm. So this is our little dynamic duo. So I'm going to get with David's calendar, get them on our schedule, but we're going to have a bankruptcy live so that you guys understand the power of bankruptcy. It is not uncommon if you're, if you're around business people that someone has filed a bankruptcy. If you file a personal bankruptcy, life isn't over. You can still establish credit afterwards. Sometimes we get in over our head. Sometimes something goes wrong. I always say, if you've never thought about filing bankruptcy or had a bankruptcy consultation, then you have not been in business, okay? Things happen. Absolutely. But there are different tools that you can use to keep your assets, okay? You can also get rid of everything and start over, but you don't have to lose everything. In fact, you will keep everything and pay less. Now, how does that sound, right? So I wanted everyone to at least see David. I mean, they see you on the flyer, but he's a real person. He exists. He's there. And we are going to have a bankruptcy live, so you guys understand. I want you guys to understand all the different tools we have to acquiring assets, protecting assets, keeping assets. And a lot of people aren't talking about this. They always hear like bankruptcy. Oh my God, honey, at the country club, people are filing bankruptcy left and right. It's just a part of business. Like you file an LLC, you file bankruptcy. Like we are just doing whatever we got to do to keep things together, to keep things going. Okay, so thank you, David, for logging on impromptu. I appreciate that. Thank you once again, Charlie. I'm going to put both. Although David hasn't spoke, I'm going to still put his Instagram on there. If you have bankruptcy concerns, they're at the same law firm. You can contact David for bankruptcy. You can contact Charlie for estate planning and trust. But I hope everyone learned something tonight. If we can't afford a trust yet, that's fine. Put it on your to-do list. When you get some money, that's the first thing I'm going to do is make sure I have my trust, my power of attorney for my finances and for my medical side. If you are a business owner, let me get my monkey. Hold on. If you have the monkey on your neck, right? The creditors are calling. That loan is 2 months behind. You are hiding your car in your friend's garage because you don't want it to be picked up. That wife is cussing and fussing at you. You done took the kids out of private school. Life does not have to be like this. There is a way to get the monkey off of your neck. And bankruptcy is one of those things, okay? So you do not have to hold it all together. If you are a business owner right now going through that struggle, go ahead and call David. Don't call him tonight, call him tomorrow, okay? But there are ways that we can kind of get the monkey off your back so that you can still go. And people always say, well, why would you gotta file bankruptcy? Things happen. You can have a bad season. Your equipment could break down, and now that took your profit margin 30% down. Maybe you were sick and you weren't able to run the business. Things happen in business, but you don't have to lose the business. You don't have to lose your assets, and you don't have to lose your spouse at home cussing and fussing because she said don't get that loan, right? So we're going to get that monkey off your back with David, and we're going to protect our assets with Charlie. I will post everyone's information in the comment. And Attorney Charlie, Attorney David, thank you so much for joining me on this live.
All right. The only thing I'll add Only thing I'll add is that I probably need to get one of those ring lights because I see my picture is really jacked up compared to both
I got
of you
you.
guys. So
Hey,
maybe
David,
maybe Charlie will bless me with a ring light.
someone,
Since he didn't get
so
me a
Joy,
Christmas
someone
present.
said they need David on tomorrow, like high
Tomorrow.
demand.
Yeah.
Hey,
Yeah.
listen, I have been 18 years in business, okay? You need to know all the avenues, right? You may not have to file bankruptcy, right? But you at least need to have a consultation because maybe, I understand the pressure of trying to hold all this stuff together. Sometimes once you let it go and you get a fresh start, you may have gotten too much debt, or you may have just gotten a bad loan. You may have gotten a hard money loan, a high interest loan. You were shooting yourself in the foot from the beginning. There is no need to have a heart attack, a stroke, lose everything trying to hold something together that wasn't meant to be together. Sometimes discharging that, yes, the bankruptcy will hit your credit, but guess what? You'll be able to breathe. You'll be able to enjoy life. You'll be able to now be creative. Now that all that the phone, the creditors ain't calling you, all that stress is off you. Now you can think. Now you can either revamp your business, start a new business, do something else. But now you can just function. Now you're back to being you. If you're going through that financial stress, you are not you, and you need some kind of relief. So David's going to be our relief pitcher. David won't be on tomorrow because I did not contact him about his schedule, but I will be able to leave his number and you can book a consultation so he can help you get the monkey off your back, okay? Thank you guys from the Hands Law Firm for joining me. I will post this live on my page. Everyone needs to go follow David's page and Charlie's page so you have both your heavy hitters on deck so you know who to go to, and they also post tips and things about asset protection and bankruptcy, okay? Everyone have a good night. Thank you, guys.
Hey, take
Bye.
care, everybody.
Oh, now I don't know how to end the live. Okay, now it's just me and David. Okay. Bam, now it's just me. Oh, I touched my screen to let David on. Okay, I gotta turn my phone off. Bye, y'all.